Hello and welcome to Courts Today by Live Law. Let us get to today's top headlines. The Delhi High Court has denied anticipatory bail to former IAS Puja Khedkar. Jammu and Kashmir High Court has held that face covering by women advocates violates BCI's dress code. The Kerala High Court has stopped the Sunburn festival to be conducted in Wayanad on New Year's Eve upon a plea by the residents. On the lack of judges' accommodation, the Punjab and Haryana High Court has remarked that Judiciary, which is a third pillar of democracy, seems to be treated shabbily by the state government. Bhima-Koregaon Commission has refused to summon Chief Minister Devendra Fadnavis as a witness. And the Telangana High Court has granted anticipatory bail to 6 persons accused of attacking a district collector. I am your host Urvashi Chauhan with your daily roundup of legal updates from across the country. Before we move ahead, let me tell you Live Law Academy is offering a value-packed opportunity for the aspiring judges out there. I am talking about the Judicial Services Examination Preparation course. This comprehensive online course is designed to help you prepare for your judiciary exams. The classes are conducted by expert faculty, including retired judges. You would learn from actual case studies and other easy-to-follow study materials. And all of this comes at a very affordable fee. So if you are gearing up for the judiciary exams, this is a must-check opportunity. Enroll today and get 25% scholarship. Hurry, because you can avail the 25% scholarship only till 31st December this year. For more details, do check out www.livelawacademy.com. We have also provided the link in the description. The Delhi High Court has today dismissed the anticipatory bail plea filed by former probationer IAS officer Puja Khedkar, who is accused of misrepresenting and falsifying facts in her application for Union Public Service Commission Civil Services Examination 2022. Justice Chandradhari Singh denied anticipatory bail to Khedkar, observing that prima facie a strong case is made out against her. The court also vacated the interim protection from arrest which was granted to her in August this year. The court observed that prima facie she is not a fit candidate to avail the benefits meant for disadvantaged groups and that she has been availing the benefit by forging documents. It said that steps taken by Khedkar were a part of a large conspiracy to manipulate the system and that investigation will be affected if she was granted anticipatory bail. Noting that UPSC is one of the most prestigious examinations in the world, the court said that it was a classic case where fraud is committed by Khedkar not only with the constitutional body but also society at large. It was Khedkar's case that she will cooperate in the investigation. She claimed that her custody was not required as all the evidence is documentary in nature. On the other hand, the Delhi police had said that her custodial interrogation was necessary to unearth the involvement of other individuals in this matter. If you recall, in July, the UPSC had cancelled her candidature and debarred her permanently from all the future examinations and selections of the commission. As per UPSC, she was found guilty of acting in contravention of the provisions of Civil Services Examination 2022 rules. In the next update, the High Court of Jammu and Kashmir and Ladakh has categorically held that women advocates cannot appear before the court with their faces covered, citing clear provisions under the Bar Council of India rules. The bench of Justices Moksha Kazmi and Rahul Bharti emphasized that Bar Council of India rules governing the dress code for advocates do not permit such attire and stressed the importance of maintaining decorum and professional identification in courtrooms. The matter was triggered when a woman identifying herself as advocate appeared before the court wearing a face cover. Upon being requested to remove it for identification, she insisted that it was her fundamental right to appear in such a state of attire. This led the court to direct the Registrar General of the High Court to confirm the legal and rule position regarding the dress code for advocates. The court scrutinized the legal framework under the BCI rules, specifically Chapter 4, Part 6, which prescribes the dress code for advocates appearing before courts. The court noted that according to these provisions, women advocates may wear black full-sleeve jackets or blouses, white bands, saris or other subdued traditional attire along with a black coat. However, there is no mention or allowance for inclusion of face coverings as part of the prescribed courtroom attire. Noting the practical and legal challenges posed by advocates appearing with covered faces, the court said that it requires clear identification of advocates to maintain the sanctity of judicial proceedings. By refusing to comply with the request to remove her face cover, the individual here had rendered herself unidentifiable, thereby compelling the court to decline her appearance as an advocate. The Kerala High Court has declined the disaster management authorities and other concerned authorities to ensure that the Sunburn festival is not conducted in Wayanad unauthorizedly. The event is advertised to be conducted on the New Year's Eve. Justice Ziad Rahman A took note of the fact that the organizers had not obtained the necessary permission. The court also considered the enormity of the program and that it is proposed to be held in a landslide-prone area. The division bench of the High Court, considering the issue of rehabilitation of victims of Wayanad landslide, had earlier asked as to how this program could be held soon after the disaster. This case was filed by the residents in the area where the program is planned to be held. They approached the High Court to stop the event, saying that the area had been identified by the Disaster Management Authority as a landslide-prone area. The Panchayat Secretary informed the court that though they have received a request seeking permission to conduct the event, it had not been granted. The District Disaster Management Authority informed the court that they had issued an order asking them to stop organizing the proposed event. The court has now directed the authorities to ensure that organizers do not go ahead with the event without the requisite permission. And even if the permission is given, the authorities should ensure that all the conditions imposed are strictly complied with. The Punjab and Haryana High Court has taken a serious note of the shortage of space and accommodation for judicial officers in the state. Chief Justice Sheel Nagu and Justice Anil Kshetrapal were hearing two PILs filed by District Bar Association Malarkolta pertaining to shortage of space in district courts and accommodation for judicial officers in Punjab and Haryana. The court remarked that it was a sad situation where the state of Punjab was treating the third pillar of democracy, that is judiciary, very shabbily. The court noted that in subdivision Dera Bassi district Mohali, 3 judicial officers are holding court on the ground floor of a double-storied building in which sub-divisional magistrate's office is situated on the first floor. The court further noted that when comparing the conditions of the SDM's office on the first floor with that of the 3 judicial courts on the ground floor, a stark difference was quite evident. The SDM's office on the first floor had been well renovated and furnished and well maintained in a habitable state, whereas the ground floor, which housed the 3 courts, was dilapidated and in urgent need of repairs and renovation. The court said that it was compelled to pass stringent orders to avoid the situation from becoming worse in the face of a new batch of newly recruited judicial officers joining in March-April 2025. Thus, the court directed Subdivisional Magistrate Dera Bassi to vacate the first floor premises within 2 weeks. It also instructed the Punjab government to issue an allotment order for the entire building to the Subdivisional Judicial Courts at Dera Bassi. Additionally, the government is to ensure repairs to the ground floor, fully furnish it and submit report of the habitable premises. Moving ahead, the 2-member commission investigating the 2018 Bhima-Koregaon violence has rejected the request by Advocate Prakash Ambedkar, who is a Dalit leader and representative of the Vanchit Bahujan Agadi Party, to summon Maharashtra's Chief Minister Devendra Fadnavis as a witness. Ambedkar had sought Fadnavis's testimony regarding the delay by the Pune Rural Police in informing him about the violence, despite Fadnavis holding the Home Minister portfolio at that time. This violence occurred when Dalit groups commemorating the 200th anniversary of their victory over the Peshwas clashed with the right-wing groups in Pune. The commission, constituted in 2018, has been investigating the incident and is expected to present its findings in 2025. It has faced multiple extensions over the past 7 years. Advocate Prakash Ambedkar had formally applied in 2023 to call Fadnavis, the State Chief Secretary and the then Superintendent of Police as witnesses. During his final submissions, Ambedkar reminded the Commission of this application and reiterated his request. However, the commission members, retired Justice Jai Narayan Patel and Sumit Mullik, decided that summoning Fadnavis and others was inappropriate at this stage. Let me also tell you here, Fadnavis had made a statement in the Maharashtra State Assembly about the violence, where he mentioned the presence of 200 to 300 individuals with saffron flags at the site on 1st January 2018. And lastly, the Telangana High Court has granted anticipatory bail to 6 people, including a woman, who were accused of attacking a district collector and other officials in Lagcherla village. The incident occurred during a public hearing regarding the proposed pharma company in the village. The alleged attack was carried out by the villagers protesting the proposed pharma company. According to the complaint, when the district collector and officers arrived at the village, a group of people, including the petitioners, formed an unlawful assembly. They stopped the collector's vehicle and attacked the special officer. Fearing further violence, the officers quickly moved the collector to safety. The accused also damaged another vehicle belonging to the district collector. They were charged under several sections of IPC, including writing, attempt to murder, wrongful restraint, and mischief. Justice K. Lakshman considered the charges and noted that for a charge of attempt to murder, there should be clear intent to kill or knowledge that the act would lead to death. The court also mentioned that the punishments for most of the charges here, except for attempt to murder, are less than 7 years. The court reviewed witness statements and found that there was no clear evidence that the petitioners intended to kill the officers. It was also noted that the injuries sustained by the officers were not serious. The court also pointed out that names of one of the accused was added later in the investigation, and there was no specific actions against the petitioners mentioned by the witnesses. The court has granted anticipatory bail to the petitioners, stating that if they are arrested, they would be released on bail with conditions such as personal bonds, weekly appearances before the investigating officer, and to cooperate with the investigation. For more information on the cases that we discussed, you can visit our website at www.livelaw.in. Your support means the world to us. So please do not forget to like, share, and subscribe to our channel. You can support us by clicking the thanks button below our videos or by becoming a member for just 89 rupees per month.